The Supreme Court heard challenges to the Texas abortion restrictions Monday. Under the law, which is the strictest in the country, private citizens can sue anyone involved in the process of obtaining an abortion. Advocates warn it is the biggest legal threat to abortion rights in decades. Natalie Brand reports.
Abortion is healthcare.
Healthcare is a right. Let their hearts beat.
Demonstrators gathered outside of the U.S. Supreme Court as the justices heard two challenges to the strict Texas law that restricts abortion as soon as a fetal heartbeat is detected.
It is important to protect life in law.
If someone needs to have an abortion, they should be able to do so.
But Monday's arguments focused on legal questions around the law's enforcement mechanism, not abortion itself. The statute allows private citizens to bring civil lawsuits with penalties of at least $10,000 for violating the law. Abortion providers and the Biden administration say that the law was intentionally designed to try and evade federal review.
It's an attack on the authority of this court to say what the law is and to have that judgment respected across the 50 states.
The Texas Attorney General argues neither the providers nor the U.S. Justice Department has the legal standing to sue.
The United States cannot seriously assert that the Constitution requires pre-enforcement federal judicial review.
In exactly 1 month, the High Court will hear arguments on a Mississippi law that bans abortions after 15 weeks of pregnancy. That case is a direct challenge to the landmark Roe v. Wade decision that legalized abortion in 1973. The high-stakes arguments come as many conservative-leaning states across the country have passed abortion restrictions. It's part of an effort to get the issue of abortion before the newly conservative Supreme Court, with 6 conservative justices, including 3 appointed by former President Trump. Natalie Brand, CBS News, the Supreme Court.
CBS News legal contributor and former Manhattan prosecutor Rebecca Roiphe joins me now with more. She's a professor at New York Law School. Rebecca, welcome. Good to see you again. So break down this legal challenge for us. How could the court's ruling change things not only for Texas, but nationally?
Right. So as Natalie was explaining, this really is not a referendum on abortion and abortion rights. This is a question about whether abortion providers or the U.S. government can sue to block this law. Now, that sounds like a really dry procedural question, but it's actually really important because the underlying question that's at issue here is whether states can use creative legislative tools to essentially deny rights that are constitutional rights that are unpopular in those states. And so that does have nationwide implications as some of the justices were pointing out, like Justice Kavanaugh, this could affect rights on both the left and the right. So a state could, for instance, create a law that looks like this one that creates a private right to sue about gun rights or something like that. So you can imagine that what's really going on here is about whether the states can essentially veto a constitutional right that the Supreme Court has established in the past.
Well, could this ruling impact an upcoming challenge to Mississippi's abortion law?
No, it really isn't. It doesn't bear on that ultimate question at this point of whether or not the underlying abortion rights that were established in Roe v. Wade and another case called Casey still stand. So that's a separate question that the court will ultimately very soon decide because of that upcoming case in Mississippi, which really does have to do with the substantive rights. But because this is about procedural rights, it's really a different case and it really does not have to do with the same subject.
Well, Chief Justice John Roberts voiced concerns about whether the Justice Department is seeking a, quote, injunction against the world. Rebecca, what did he mean by that?
Right. So that was kind of a colorful way of saying, the Justice Department can't just go out and it doesn't have any freewheeling right to just go out and sue when it doesn't like something. So there has to be what's called a case or controversy, and that requires a specific and particular harm. And here, it's very hard to point to what is the harm to the federal government. And so this is a very unusual case. The reason why the case is unusual, which the Solicitor General kept emphasizing, is because the Texas law itself is unusual, and really unusual in trying to skirt federal review. And so what Justice Roberts was saying was, what are you trying to do here? You just can't go out and sue in courts when you don't like whether something happens. That's not how our system works. There are rules and procedures that are important here.
Well, Texas says it has no control over private lawsuits to enforce the state ban. To what extent is that true?
I think that's a bit of a specious argument, or, a kind of lawyerese, because essentially what this law did was create the private rights of action. So what Texas is trying to do is say, oh, well, we enacted this law and now we kind of wash our hands of the results. But of course, it doesn't really work that way. These private parties only have the power to sue because the legislature created that power. So it isn't quite right. It's technically true that now the state doesn't enforce the law, private parties do. But to say that the state has nothing to do with the enforcement of the law isn't accurate, because of course the state created the possibility of these private parties enforcing the law.
Well, do you see Texas's abortion law as encouraging private lawsuits for potential personal gain?
Well, of course, that's exactly what it's doing. That's exactly its intention, which is it's deputizing these private parties by incentivizing them with this $10,000, and so they can go forward and enforce the law for the government. And by doing that, they create a kind of loophole, which makes it very hard for anybody to sue. And here we see the Supreme Court grappling with this question. Can the Texas legislature do this? Can it create these procedural hurdles such that no one can really review or try to block this law because it is, challenging its constitutionality, until way down the line? And that's what's at issue here. And it has implications beyond just this case, because of course, if the Supreme Court did uphold this particular a route of the legislature creating these procedural barriers, then, states across the country will mimic this.
All right, really high interest case. Rebecca Roiphe. Rebecca, thank you very much.
Thank you so much, Elaine.